Hi, I'm Damin Murdock, principal lawyer at Leo Lawyers. Although this looks and sounds like me, what you're watching is actually my AI avatar presenting from a script that I've written and approved. Injunctions are one of the most powerful remedies available under Australian law. They can stop someone from doing something or force them to do something, sometimes urgently and sometimes permanently. If you're dealing with a breach of contract, misuse of confidential information, employment restraints, or asset protection issues, injunctions can be critical. In this video, I'll explain the common types of injunctions, how they work, and the practical issues you need to understand before applying for one. At its core, an injunction is a court order. It can either restrain a party from taking a particular action or compel them to perform a specific duty. Courts in Australia can grant injunctions under both statutory and common law. They also have flexibility to grant temporary relief, like interim injunctions, or final relief, like permanent injunctions, depending on the circumstances. Understanding the different types of injunctions is essential because each comes with different legal thresholds and risks. The most common type of injunction is a prohibitory injunction. A prohibitory injunction is designed to prevent or restrain particular conduct. Importantly, the court can grant this type of injunction even if the respondent hasn't yet engaged in the conduct. There does not need to be an ongoing breach, repeated conduct, or even imminent danger of substantial damage in every case. The focus is on preserving the status quo and preventing harm before it occurs. Courts have broad discretion to grant prohibitory injunctions where the balance of convenience supports it. Common examples include restraining the transfer of funds, stopping the use or disclosure of confidential information, or preventing someone from working for a competing business. Mandatory injunctions work differently. Instead of stopping conduct, they compel a person or entity to do something. Because of that, they are generally more difficult to obtain. To succeed, the applicant must usually show that the respondent has failed or refused to perform the required act, and that there is a strong likelihood of continued noncompliance or breach. Mandatory injunctions commonly arise in breach of contract disputes, property matters, and regulatory noncompliance. Examples include requiring the delivery up of confidential information or enforcing a restraint of trade or non-compete clause in an employment contract, contractor agreement, or shareholders agreement. A permanent injunction is granted after a full hearing of the matter. It provides final relief and may include both prohibitory and mandatory elements. In some cases, it can also be accompanied by an award of damages to compensate the applicant for harm already suffered. Permanent injunctions are often used where ongoing or repeated breaches need to be stopped permanently. Ex parte injunctions are granted without notice to the respondent. These are typically reserved for emergencies where giving notice would defeat the purpose of the injunction. For example, freezing a bank account where advance notice would likely result in funds being transferred. These orders are usually short-lived and designed to protect the applicant's position until the other party can be heard. Applicants seeking ex parte relief must provide draft pleadings, affidavit evidence in accordance with Section 75 of the Evidence Act, and full disclosure of all matters that may affect the court's decision. Failure to make full and frank disclosure can result in the injunction being set aside. Injunctions are discretionary remedies. They are never granted as of right. To obtain an injunction, an applicant must demonstrate either past misconduct or a strong likelihood of future misconduct. Contrary to popular belief, there is no strict requirement to show imminent danger in every case. Courts will weigh the balance of convenience, consider whether damages would be an adequate remedy, and assess whether granting the injunction is in the public interest. In practice, injunctions are often sought alongside claims for declarations or damages, particularly in commercial disputes, intellectual property matters, employment law, and regulatory enforcement. Injunctions can be incredibly effective, but they also carry legal and strategic risks. Choosing the right type of injunction, preparing the right evidence, and understanding the court's discretion is critical. At Leo Lawyers, we regularly advise on urgent and complex injunction applications. If you need tailored advice, you'll find our contact details in the description box, or you can visit us at leolawyers.com.au. Thanks for watching.